Right, good morning, everyone. The Court of Appeal for Bermuda has assembled today for the hearing of Civil Appeal number 22 of 2021, Jonathan Ingham and Nicholas Ingham against Claudia Wardman and others. This appeal is taken before my Lords Sir Christopher Clark, President, Justice of Appeal Jeffrey Bell, and Justice of Appeal Sir Anthony Smelly. Ms. Constance McDonald, QC, is on behalf of Ms. Constance McDonald and Richard Horseman, appearing on behalf of the appellants, and Mr. Robert Ham, QC, and Keith Robinson, appearing on behalf of the respondents. My Lord President.
Well, good morning or good afternoon, according to wherever you may be. Very good to see you all. I should indicate that we propose to treat the appeal in relation to the Beddoes order as a rolled up case. In other words, the application for leave to appeal and the appeals be run together, and we'll decide both of them in the light of the submissions that we receive. Yes, I think it's you, Miss McDonald.
Thank you, my lord. May it please your lordships, I appear with Mr. Horseman on behalf of the appellants, Jonathan and Nicholas Ingham. My learned friend, Mr. Ham, QC, appears for the executors together with Mr. Robinson. My lords, you should have three bundles, one being the record of appeal in the privacy appeal heard in March, one being a record of appeal in the Beddoes appeal, and there should also be a joint authorities bundle.
Ms. McDonald, I don't have separate records in relation to the Beddoes appeal and costs, but it may well be that the two have been combined. I've got 15 tabs in my record of appeal.
As do I in the electronic version, which is what I've got so far.
That is the Beddoes appeal bundle, I believe.
So there's a separate bundle?
There was the bundle, my lords, that we used at the March hearing in the privacy appeal, which had 26 tabs in it.
Well, that I don't have with me, but I expect I've got the material somewhere.
My lords, for myself, I'm not going to take you to any document in it, so I think we can probably manage.
Right. I don't have it either, but it seemed to me that we needed practically nothing from it anyway.
Indeed. Your lordship's judgment is what we need.
I've got that.
My lord, so you've had a fairly detailed skeleton argument from us. Obviously, I'm not going to, I hope, repeat any points made in it, or at least certainly not unnecessarily. There are a few points I propose to highlight, particularly in rebuttal of some of the submissions made by the executors. It is worth noting that there are some key submissions made by us which don't appear to have been responded to by the executors in their written submissions, which I propose to leave for reply and to deal with only if necessary, and in particular the submissions we made about the construction and effect of the exoneration clause in Mrs. Chappell's will, which took up some pages in our skeleton argument.
Could we just spend some time on that, because it is true they don't refer to the exoneration clause, but that notwithstanding, I have been looking at the exoneration clause. I'm just turning it up in the will. It's at paragraph. It's at page 313 of the bundle.
Yeah.
And I want to make sure that I'm not missing something. It seems to me that the relevant provisions eliminating portions of it mean that the clause reads, in the professed execution of the trusts hereof, no executor or trustee shall be liable for any loss to the trust premises arising as a result of, and then one can skip down to the penultimate line, any other matter or thing, except willful and individual fraud or wrongdoing on the part of the executor or trustee who is sought to be made liable. I find some difficulty in seeing how ordering the trustees themselves to bear the costs of the appeal and the hearing at first instance without resort to the trust fund by way of indemnity would mean that the trustees are being made liable for any loss to the trust premises arising from their wrongdoing.
My Lord, could I perhaps intervene at this point to say that that is precisely why we haven't dealt with the exoneration clause, because we don't think it's got anything to do with the issues. It's
fine.
headed indemnity, and indemnity is used in a rather flexible sense often in trust instruments, but this is an exoneration clause protecting them from liability for breach of trust. It's not about reimbursement of expenses out of the trust fund.
So, Ms. McDonnell, your submissions, although interesting, were in fact irrelevant.
Well, I am for once happy to hear that.
Yes, I thought you might be. Right, okay.
I'm grateful for that. The position wasn't clear from some of the pre-action correspondence, which is why we dealt with it, but we can move on. My Lords, the costs of this appeal, the privacy appeal, both in this court and below, are straightforward on an inter partes basis, in that they are not contentious. The principle is agreed that as the successful party in the privacy appeal, my clients should have their costs paid by the executors. The battleground is whether or not the executors should bear such costs personally without any indemnity from the estate for either their own costs or for any adverse costs ordered against them. And I suppose it follows from that whether they should be ordered to repay any costs already deducted from the estate. It may be helpful, my Lords, just to establish at the outset the timeline, the chronology here.
Yes.
And I'm going to make some references to page numbers in the Beddoe appeal bundle. Your Lordships don't necessarily need to look at every page because the documents are very straightforward. The 10th of February 2022, an Beddoe order was made ex parte. And the page reference is 249.
Yes.
The executors seek to take no blame for the fact it was made ex parte, but by way of a footnote, the reason it was made ex parte is probably because in their draft order lodged with the application, there was a recital that no other party need to be served with, need to be given notice of the proceedings. So the order was made ex parte on the 10th of February. On the 25th of February, there was a hearing.
Yes.
And Mr. Horseman represented my clients at that hearing. And at the hearing, the judge both affirmed her Beddoe order and refused to make it subject to any further or different order which this court might make.
Yeah.
The page reference is 253 for that.
Yes.
The submissions made by each side at that hearing in writing are at page 280 following of the bundle. The Inghams, my clients, pointed out to the judge that the executors, and this is at page 283, I think at this point, would your Lordships turn up that particular page? The Inghams submitted that the executors were the only party who wished to obstruct the use of the permission documents and that they had adopted a non-neutral position. And we then...
Which paragraph are you at there?
I'm so sorry.
11.
Sorry, paragraph 11. Thank you.
Paragraph 11, indeed. Over the page, at page 284, at paragraph 13, we made the point that the privacy order had been made pursuant to a consent order made by all beneficiaries in Guernsey. And then we took the judge to the law, including the key paragraphs from Lewin. Over the page at paragraph 16 to Alsop, Wilkinson and Neary. And briefly over the page again at paragraph 19 to Armitage and Nurse. And we noted to the judge that the executors had failed to explain why our submissions, why the reasons for the privacy appeal were not good. They simply had not engaged with them. We also noted that until the privacy appeal was concluded, it would not be known by the judge whether or not the executor's costs were justified, and it wasn't appropriate to seek cost protection in advance. I'm told by Mr. Horseman that at the hearing, he did indicate orally that his clients would appeal, and I'll come back to the chronology of the appeal in a moment. Before departing from the submissions made at the hearing on the 25th of February, the executor's submissions are at page 292 following.
Can I just go back, Ms. McDonald, to your statement or your reference to Mr. Horseman saying that they would appeal? Was that a reference to the substantive appeal or to the appeal of the judge's better order?
The appeal of the judge's better order.
Right.
The appeal from the privacy, the privacy appeal was already pending. Notice to appeal that had been lodged in December last year.
Understood. So Mr. Horseman's statement came after the judge had indicated that she declined to vary and yes.
The executor's submissions are at page 292 following. And they, in their introduction, noting the pre-reading, they, at paragraph 2, asked the court to review the 5th affidavit of Mr. Kemp and its confidential exhibit, which was the legal opinion from Kerry Olson. They referred the judge, in terms of the law, they referred the judge to the Trustee L case, which I will come back to a little later, being the fairly recent Bermuda judgment. And your lordship see that at paragraph 15. The focus of the court's inquiry is whether the trustee's proposed course of action is reasonable. In fact, Trustee L developed what the question of what is reasonable, and so I will come back to that. But they didn't, despite the fact they referred briefly to Trustee L, they didn't explain to the judge why it was reasonable, or certainly not adequately, why it was reasonable for the executors to resist the appeal. The closest they got to doing so appears to us to have been in paragraph 21 at page 297, where they submitted to the judge that the outcome of the appeal had the ability to negatively impact their ability to properly administer the estate for the benefit of the beneficiaries and to defend the permission application. There was also a slightly vague suggestion that the obligation the privacy order would impose upon them to keep the permission documents secret, that's their word, was not in the interests of the estate. That is in the next paragraph, paragraph 22. It's hard for us to understand that submission. And they also refer at the foot of the same paragraph, paragraph 22, to the fact that the privacy order has already been set aside. We infer that they submitted that was somehow made it reasonable to resist the appeal. And there's also a reference to the January 2021 Bedo order in relation to the permission application, and which is mentioned at paragraph 26 in the penultimate sentence. If there is a link between that and the reasonableness of resisting the appeal about privacy, it's not spelt out in the submissions. So, my lords, nowhere in these submissions do the executors set out the correct legal approach by reference to Alsop, Wilkinson and Neary and their duty to remain neutral. And they simply don't articulate why it was reasonable for them to resist the appeal.
What the approach, so far as I can understand it from the executors, is that it was reasonable to resist the appeal if there was a reasonable prospect that the appeal would fail.
Well, they certainly focus heavily on the merits, and that is the one point that's made in Mr. Kemp's affidavit exhibiting the opinion. But as I'm going to come on to show your lordships by reference to a couple of the authorities, the question of merits is only one of the factors that the court needs to take into account on a Bedo application. It must be put in context, the commerciality must be considered, etc. I will come back to that. So that was the hearing on the 25th. On the 28th, we filed notice of appeal and in the Supreme Court, and that's at page 255. And on the same day, the judge refused permission. And the page reference for that is 269. On the 1st of March, we renewed the application to this court and asked for it to be heard at the same time as the privacy appeal. And the reference for that is page 267. Mm-hmm. Your lordships may recall that the hearing of the privacy appeal was supposed to take place on the 10th of March, but you very kindly postponed it to the 14th to allow me to travel. And the Bedo appeal was not before your lordships on the 14th of March due to perhaps a misunderstanding at listing level. The executors, though, it's worth noting, resisted the privacy appeal and the Bedo appeal being heard at the same time. And indeed...
Where do we see that?
The reference, my lords, is at page 332, very end of the bundle. Which is absolutely subsequent to the hearing, but and perhaps I'm saying this because I was there and lived it at the time, but they did resist them being heard together. You see from Mr. Horseman's email at page 330 that we were asking for the two to be heard together in response to an email from the executors. And over the page at page 331, your lordships have a letter from the executors' lawyers dated the 11th of April, where they in fact asked at the top of the second page of it, 332, for the Bedo appeal not only to be, they sought to punt it off into the long grass to be heard either after the permission application in the derivative claim or indeed after the determination.
Sorry, I don't have exactly where you are on 332.
I'm so sorry, I'm at the top.
I'm on 332.
Yes. The second sentence, my lord.
The question as to whether our clients,
yes, are entitled to be indemnified from the assets of the estate, including whether leave to appeal ought to be granted in respect of the appeal Bedo order. could await the conclusion of the permission application, or if it's granted the substantive derivative claim.
Right, thank you.
That concludes the chronology of the Beddoe appeal. And the headline point that we make from this is that the Beddoe appeal was pending when the privacy appeal was heard. And therefore, quite apart from the points I'm about to come on to, the executors should have realised that there was a risk that the Beddoe order would not survive.
It could be said against you that you should perhaps have made application for a stay of the privacy appeal pending the determination of the outcome of the Beddoe appeal.
My lord, I suppose we could, but that of itself should not make the Beddoe order a get out of jail free card. Partly for the reasons I'm going to come on to, and partly because we did try very hard to get the two listed at the same time. And it was only, Mr. Horseman will correct me if I'm wrong, but I think it was only really a matter of a day or two before the hearing that we realised that they weren't going to be heard at the same time.
I suppose it could be said that if you could have asked for a stay, the executors themselves could have suggested that the Beddoe appeal should be heard first and the privacy appeal second.
Which would very obviously have been in their interest, my lord. Yes. My lords, our next key submission is that the executors are seeking to attach weight to the Beddoe order made in February, which it cannot bear. And there are three main points here, which I will expand in a moment. Firstly, a Beddoe order is not conclusive of any matter. Secondly, a Beddoe order is only as good as the information provided to the court by the applicant for it at the time it's made. And thirdly, the Beddoe order in this case was not made by an independent judge who had no other involvement with the proceedings. It was flawed from the outset. Now, the point about a Beddoe order not being conclusive is probably best explained in the case at tab 13 of the authorities bundle, the decision of Mr. Justice Lindsay and 3 individual present professional trustees. So would your lordships please turn that up, tab 13. In that decision, in particular on this point, I'd ask you to look at paragraphs 25 and 28.
Do you say this is the Heidelberg, Ms. McDonald?
This is in the authorities bundle.
Right, the case is the Heidelberg, is it?
No.
No, it should be Mr. Justice Lindsay, and the case is called 3 individual present professional trustees.
Page 177 is where you're going.
Yes, I have it at tab 9 in the hard copy. But
No, I have it at tab 13.
13.
Be at page 177, by the way.
There may be 2 different authorities bundles floating around, because I believe that Mr. Ham may have lodged a bundle of his authorities separately, and then we consolidated them into a joint bundle.
I've only got the joint bundle.
I've only got the joint bundle.
That will make life easier.
I have it as an electronic bundle, but tab 13 is a different case. Anyway, I've found the case, and if we please just give me the names of each one as we go along, that would be...
Certainly, my lord. So in the 3 individual trustees case at paragraph 25.
Yes.
About halfway down the paragraph, there's a line beginning, but even where the proceedings are launched or are continued, a trustee will not, in my view, as a matter of inescapable necessity, get his costs out of the trust estate. If, for example, it transpires that the picture which the trustee painted before the judge in order to get the Beddoe relief was materially inaccurate, and that the inaccuracy was the trustee's fault, the trustee could, in my judgment, and without inconsistency with MacDonald and Horne, find himself vulnerable in costs. In that sense, the Beddoe hearing, strictly speaking, determines nothing relevant. And at paragraph 28, the judge refers to a decision of the Vice Chancellor, as he was then, Sir Andrew Morritt, in a case called the Trust of X Charity, in a slightly different context, just making clear that the Beddoe jurisdiction is designed to provide guidance to the fiduciary. It only rarely could it be said to determine the rights of anyone.
Yeah.
So there are limits on what a Beddoe order does, and it is not a cast iron guarantee that in any circumstances the person who obtains the Beddoe order will have a shield against cost liability. And that brings me on to the second of our submissions on this, which is that the Beddoe order is only as good as the information provided to the court at the time it's made. And in the same case that we were just looking at, Mr. Justice Lindsay explains this probably better than in any of the other authorities before your lordships. There's quite a long explanation of this at paragraphs 20 to 33, but we would highlight in particular paragraphs 20 to 21 to begin with, which makes the overarching point that, and I'm looking at the last three lines of paragraph 20, that the immunity to the trustees is subject to a caveat. And the caveat is explained at paragraph 21, that the position, i.e. the immunity, may be otherwise if the trustee had failed to make a sufficient disclosure at the Beddoe stage. And the expression disclosure shouldn't be read in a limited way. At paragraph 22, it's expanded clearly to cover, in my submission, anything that's relevant to the court's discretion as to the making of a Beddoe order. And that's explained further at paragraph 24. And paragraph 25 that we looked at a moment ago.
Let me find what you're
So sorry.
referring. What are you relying on in 24? Well, I can go back and read it if you prefer.
No, my lord, it's the same point that's made in slightly different ways. And it's that the obligation of the trustee to make full disclosure, using that expression in a broad sense, to the court at the Beddoe stage is broader than simply telling the Beddoe judge about the key facts of the case. And it goes broad, it's broader than just telling the judge about the merits. The court needs to, sorry, the trustee needs to go into the merits, but needs further to, in the words used at paragraph 25, paint a picture for the judge, so that the court makes a Beddoe order based on an accurate picture of what is going on in the litigation.
And presumably, Ms. MacDonald, you're saying that the principal failure of the executors was in relation to the duty to remain neutral per Alsop Stevens, Alsop Wilkinson.
Yes, that's an absolutely key aspect. But there are other nuances to it as well, such as the fact that the beneficiaries had all agreed to the Guernsey consent order. And there was no attempt to analyse, or proper attempt to analyse, why it would be in the interests of the estate for the costs of the setting aside the privacy order application to be incurred, still less the appeal. Just before I leave the Mr. Justice Lindsay decision, may I ask you to look at paragraph 32? This is expressly cited in the executor's written submissions for today, but only partially. And my lords, I would ask you to read that paragraph as a whole. Only
Could
the
you
first,
just let us do that?
of course, only the first sentence has been cited by the executors.
Okay, let's.
You want us to read the whole thing? Let's do that.
Please, please.
Right.
I mean, there are two different, well, a number of different questions. You say what is being discussed here is whether or not there has been adequate disclosure to the judge who makes the Beddoes order. What is the position if the disclosure is adequate enough, but the judge who makes the Beddoes order does not appear to have addressed her mind to the right question?
My lords, in my submission, the same result would occur, because if the court has not exercised its discretion properly, taking into account all relevant considerations, then the Beddoes order itself must be vulnerable, either to an appeal or certainly to a discharge at a later date once the error is realised. And the difficulty in my submission that the executors face in this case is that the matters which they failed to explain to the judge in February are absolutely fundamental matters of their conduct and their duties, the prevailing duty for this purpose being their duty to remain neutral.
That brings back to the point that my Lord Bell made. They failed to explain the Alsop-Wilkinson principles.
Yes.
And Ms. McDonald, I mean, I bear in mind that they referred to the case of Alsop-Wilkinson in the context of the judge hearing the Beddoes application being a different judge than hearing the main action. So they referred to part of the case, but didn't refer to the part on which you rely.
Yes. And they have continually resisted the acceptance of the key point that all of the beneficiaries were content with the process of the privacy order being made. And they have simply failed to explain, either at the Beddoes stage or at all, why it was in the interest of the estate to challenge it. And this is these points pervade, my lords, the whole of this appeal and the whole of the issue of the costs of this appeal, because these points should have been staring the trustees in the face and should have been clearly presented to the court, as well as concerns about commerciality, cost-benefit analysis, and the like, as well as the consideration of whether or not somebody else might be motivated to resist the appeal, which of course they wouldn't in this case because of the consent order. So all of these points should have been made to the Beddoes judge, and they simply weren't. And My Lords, just while we're looking at the authorities bundle, could I ask you very briefly to turn up tab 9, which is MacDonald and Horn, decision of Lord Justice Hoffman as he was. And in MacDonald and Horn, can I ask you to look at page 695 of the report? The disclosure point is briefly covered, but authoritatively covered at just above letter F, just recording that the BEDO procedure requires the trustee to make full disclosure of the strengths and weaknesses of his case. And then here's the caveat: provided that such disclosure has been made, the trustee can have full assurance. So the fullness of the assurance is entirely dependent upon the quality of information given to the judge.
Well, it's interesting, that formulation, because it may be that it was pertinent to the particular facts of that case. But Lord Justice Hoffman seems to be saying the relevant question is whether the judge has been told everything necessary in relation to the strengths and weaknesses of the case. But you say, well, that's part of the issue, but an equal, possibly more important issue is what is the value to the beneficiaries of making the case at all?
My Lord, that point struck me as well when I read MacDonald and Horn, and I do say that it certainly shouldn't be read as a general limitation on what should be taken into account. And to make good that point, can I ask you first of all to look at tab 4, the case of Evans, and at page 107 of, starting at 105 of that report, your lordships will see at page 105 letter F at the beginning of that paragraph a reference to the case of Reed Dalloway and the decision of Sir Robert McGarry, Vice Chancellor, where he said that in BEDO applications, the court had to form a view about the prospects of success or failure. So that same sort of point as in MacDonald and Horn. But my lords, if you move on to page 106, the foot of 106, in the final paragraph on that page, second sentence, he says that there are 3 important points to be made. First and foremost, every application of this kind depends on its own facts and is essentially a matter for the discretion of the master or judge who hears it. And then the justice of the case is considered on the next page. So the merits are considered again at B on page 107. At C on page 107, the judge is considering whether or not somebody else could be joined to the proceedings to sort of fight the corner that the trustee is proposing to fight. And then there's the injustice point, which begins in the paragraph just below D, where the court needs to step back from the issue about the merits and consider whether or not it's unjust for a beneficiary to have to indirectly pay the costs of a successful proceeding, the costs of proceedings in which they're successful, because the fiduciary, the trustee or executor seeking to take the costs out of the fund. So, my lords, it isn't just about the merits, and in that particular case, that's pretty clear, just below letter F, where the court, where Lord Justice Norse refers to, he says that sentence, I wouldn't wish to curtail the discretion of the court in any future case, but as already indicated, those considerations might include the merits of the action. It's obvious in my submission from that one sentence that the considerations do not just include.
Which sentence are you looking at?
By letter F, my lord,
Of-
but 3 lines down from letter F, I would not wish to curtail.
Oh, yes, I've got it.
Yeah. But this point is made in much more detail in a Bermuda case at tab 17, a decision of Mr. Justice Hellman, trustee L, which has been referred to by both sides. And that, your lordships will see from paragraph 1 of the judgment, was a case about Bedo relief. And there are a few paragraphs which are worth looking at in this case. First of all, paragraph 23.
It's a 5-day Beddoes hearing.
Well, it appears, my lord, that it was an extremely valuable trust. If you look at paragraph 1, the final 3 lines, it clearly was of very high value, and
Yes. Okay.
I think there were complex issues to be considered on the Bedo.
All right.
Having not been involved, I
Yeah.
don't know precisely what those were beyond the
Yeah.
judgment.
Doesn't quite fit in with the informal chat approach to Beddoes. Right. I'm so sorry.
The passage about the law begins at paragraph 12, and it's quite long. A couple of helpful points. First of all, that there's a clear passage at paragraph 21 distinguishing between the Bedo jurisdiction and the preemptive costs jurisdiction, and noting that the Bedo jurisdiction is not a jurisdiction. I'm looking now at the top of page, for some reason this page is numbered in my bundle at page 238, but it's paragraph 21, the last couple of sentences. That the Bedo jurisdiction is not a jurisdiction to award costs, but to allow charges and expensive, and is not determinative of any, sorry. And in paragraph 23, there's clarification of what the court is doing on a Bedo application, where he
Just
says,
give me a moment to finish reading 21, would you?
sorry.
Right. Sorry, after 21, you're on 22?
23.
23.
Yeah. 4th line down, the focus of the court's inquiry on a Bedo application is whether the trustee's proposed course of action is reasonable. And 3 lines down from that, of course, when deciding what is reasonable, the court will have regard both to the context in which the application is made and to how reasonableness has been interpreted in other cases. And then in the penultimate sentence of that paragraph on the next page, factors such as whether there is someone with a real interest in defending the action and the merits of the trustee's case will be highly material. But the primary question is what ought the trustees reasonably to do? So again, my lord, merits is clearly not the only relevant factor. At paragraph 40, I'm so sorry, can we stop at paragraph 34 next, please?
Just a moment. I'm just looking at paragraph 25, which I had highlighted, where it said, thus the Bedo order was to take effect only until further order. It's important to appreciate that Sir Robert McGarry was not suggesting that the trial court might undo the Bedo order with retrospective effect.
My lord, yes, but that's always going to be subject to the quality of information given to the Bedo judge.
So that those words have no relevance where you say that the applicant for better relief hasn't made the appropriate disclosure to the better judge.
My lord, yes, the context of that sentence is previously in the paragraph where it said that facts or materials might subsequently emerge, which then made it unreasonable for the better relief to continue, but that won't have the effect of retrospectively undoing the better relief. It is not said, but in my submission, it is the law that doesn't mean that the better relief can't be undone if it hasn't been properly obtained in the first place.
Right. So you then went to where, 41?
I went to 34, briefly looking at the last sentence of 34. The point is made by Mr. Justice Hellman that the trustees of a trust, last 3 lines, should exercise no less commercial prudence when carrying out their professional duties than they would when conducting their own affairs. So that test of prudence, commercial prudence, is a factor for a better application. And then at paragraph 40, it is observed in the it's observed in this paragraph that there is an analogy with preemptive cost orders, and I'd invite you just to quickly read that paragraph. My lords, for completeness, and it is quite a detailed judgment on the law, at paragraph 55, there's quite extensive reference to a Gibraltar Court of Appeal case called STG Valmet, which concludes with a finding that Bedo orders may have a lot of analogous points with preemptive cost orders, but they're not the same, and that's at paragraph 61. Nonetheless, the court in this Bermuda case seems to have proceeded on the basis that a lot of the factors that the court would consider on a preemptive cost order application are also to be considered on a Bedo application. And we see that later on in this decision, that there's reference at paragraph 62 onwards, quite extensive reference to a High Court of Australia case called Macedonian Orthodox Community Church. And at paragraph 73, the judge says that he agreed with a submission, second sentence of paragraph 73. He agreed with counsel that asking what is practical and fair was a helpful way to approach the question of what is reasonable. And sorry, I realise I'm jumping around, but the question of what is practical and fair, if your lordships go back to paragraph 71, derives from the High Court of Australia case. Right. And there are then some factors that are set out in the italicised extract from that case, halfway down paragraph 71, which we submit are the kind of factors that the Bedo judge should have been asked to take into account. And they're bullet pointed, whether the beneficiaries have a substantial financial interest in defending the claim, the financial means of beneficiaries to fund the defence, the merits and strengths, the extent to which recourse to the trust estate for defence costs would deprive the successful claimant of the fruits of litigation. So practical and financial, commercial.
And this appears to be in the context of a claim against the trust estate. And what we're dealing with here is not a claim against the trust estate, but a claim for the benefit of the trust estate.
My lord, yes, but the questions about who might be involved in the proceedings if the trustees are not directly involved about the commerciality, about the impact upon the beneficiaries of a particular outcome, in my submission, crossover and a relevant.
Oh, yes, the point I thought was a point in your favour, in the sense that if the position is that we're not dealing with whether or not the trustees should defend a claim against the trust estate, but whether or not the trustees should be party to an appeal against an interlocutory privacy order in relation to a claim which, if it goes ahead, is going to be a claim by two beneficiaries in their personal capacity against the executors of two other beneficiaries, which, if successful, which is to be financed by the first named set of beneficiaries, and which, if successful, will inure to the benefit of the estate. That is a rather different set of circumstances to those where there is a claim against an estate, and may make it more unnecessary for the trustees to be party to the proceedings.
My lord, yes, and this case, for many reasons, is quite near the extreme end of circumstances in which a better order might be both applied for and made. It is in many ways fairly extraordinary. My point is that, quite apart from the issue about merits, that the methodology used to obtain the better order and of the judge refusing to make it subject to the decision of the Court of Appeal on costs is simply lacking, because only one factor was identified to her, which was the merits. And that's all that the executors really put in front of her. There's a point which I should highlight, which we make in writing, that Mr. Kemp said in his fifth affidavit that to defend the appeal would be in the interest of the estate, and cited the opinion, the legal opinion. But the legal opinion deals only with the merits. It does not contain any advice about what would be in the interest of the estate. So there seems, and we've used this word in our written submissions, to have been an elevation of the legal opinion to do something which it did not do. And it's clear, and I'm sure it's common ground, that reliance upon a legal opinion does not of itself entitle the trustee to an indemnity for costs. It's not good enough just to say that you rely on legal advice. And in my submission, this is particularly the case, where, as here, the executors are professionals, and in one case, a company whose business is the administration of trusts and estates. An obvious point, my lords, but it's simply hard to fathom how it could possibly be said that it was reasonable to have been in the interest of the estate to resist the appeal. The executors could have taken no part in the appeal. They were not bound by any obligation to support the first instance judgment. And we've already included in our written submissions an explanation of that, both by reference to Lewin and to case law. It is not the job of a trustee or executor to justify a first instance decision in their favour, nor is it, for what it's worth, their job to appeal an unhelpful decision. They should have simply not taken part and not spent estate money taking part. The third submission, my lords, the second one was the longest of the three. The third submission is that the judge was not independent or impartial. She should not have been a Beddoe judge in the application relating to the costs of the appeal. She was hardly an independent judge who had no other involvement with the proceedings. She was the very judge whose judgment was the subject of the appeal. And in essence, she was being told by the executors that her judgment was correct and that there was therefore no merit in the appeal. And this was despite the fact that she had in fact given leave on one ground, that being the ground that there were special circumstances as a result of the fact that documents emanated from Guernsey trust proceedings, which were subject to a privacy order. she had already refused leave to appeal on all other grounds, and that refusal was published on the 9th of December last year. So the executors, my lords, should have realised that no Beddoe decision made by this judge was a safe decision and a decision on which they could properly rely. Just dealing briefly with a couple of other points. I think there's a submission made against me by the executors that the variation sought is unusual. But if I could ask you briefly to turn to tab 3 of the authorities bundle. The case of Reed Dalloway. Your lordships will see at page 761 of the report at letter H that the Vice-Chancellor in that case proposed, just by letter H on page 761, to include in the Beddoe order a provision that, subject to any order made by the trial judge, the bank was entitled to be indemnified out of the estate for all costs. So that is, in my submission, an example of the court making the kind of proviso that we were asking to be made. And my lords, putting the Beddoe order to one side, if your lordships accept our submission that the Beddoe order was not an order on which the executors could properly rely, and at the very least there should have been a carve out from it, depending on whatever order your lordships made as to costs. There is then the question of, by reference to Order 62, Rule 6.2, this is in our skeleton, of whether the executors have behaved unreasonably. Now, this is a very short point. It's in our submission clear from your lordship's judgment that the executors have behaved unreasonably. And it's not open to the executors to say otherwise. Your lordships have already found that their conduct was improper and unjustifiable.
Yes.
There's another smaller point here, which I think is worth just noting. In a case called Bredner and Granville Grossman at tab 12 of the authorities bundle, there's a point noted by the judge, Mr. Justice Park, at page 385 of the report. And I should say, I think strictly speaking, it's obiter. But he says just above letter D on that page 385, the numbers are in very small writing,
Yes,
top of the page.
Oh, gosh. Sorry, I need to find a magnifying glass.
About halfway through this is taken, my lord, from the Wills and Trust law reports.
Yes, well, I'm sure it is.
At page 161 of the record, if you could.
Oh, thank you. Yep, yes.
Yep. So at page 385, letter D, the judge raised the question of whether, when Order 62, Rule 6 referred to the benefit of the fund, it meant the benefit of the fund as a whole, and that if the summons in that case was not going to benefit of the fund as a whole, but was only going to benefit one out of several beneficiaries, that could be said to benefit the fund as a whole. So it's a sort of side question about whether or not the trustees have behaved unreasonably. But I hoped it was worth just flagging that up. Finally, on this point, my lords, at tab 19 of the bundle, authorities bundle, is a fairly recent Bermuda decision known as the FA Trust and FB Trust. And in that case, the judge, having referred to the cases I've already referred your lordship to, in writing at least, Gomba Holding and Management, and the extract from Lewin that's referred to in our written submissions, the judge concludes at paragraph 26 that an express provision in a trust deed, and this is to the extent that the executors may try and rely on what's said in the will, an express provision in a trust deed providing for an indemnity in favour of a protector, I would substitute executor, in respect of litigation costs must be construed as providing for an indemnity for litigation costs which are properly and reasonably incurred. So that is an overarching requirement wherever the indemnity stems from. Before finishing...
Well, wait, just a second, pause there for a moment. What the Chief Justice was dealing in that case was with a trust which had an exemption provision. And he says, as you've indicated at 26, there's an express provision in the trust deed providing for an indemnity, must be construed as providing for an indemnity for costs which are properly and reasonably incurred. So that is a decision upon the true construction of an exemption or an indemnity clause in a trust deed.
Yeah.
It's no more than that.
My Lord, I entirely accept that. This is really for completeness, I suppose, because there is a clause in the will.
Yes, but it's not being relied on, so we...
No, all right, well, I'll leave that point there. I don't need it.
Okay.
My Lords, for all these reasons, we say that the executors should be ordered to pay the costs of the appeal and below on the indemnity personally without recourse to the fund. We've made some submissions about assessment of those costs and that it should be on the indemnity basis. I've already set that out in writing. But my Lords, on the facts of this case, the executor's decision to attack the privacy order and to resist the appeal has been extraordinary and a complete departure from the norm. And it should never have happened. The privacy order should have remained in place. If it had done, the permission hearing would have been heard in a timely manner last July. And the blame for the disruption in the process of the permission application and the expense and delay that's been caused lies entirely at the door of the executors. My Lords, unless I can assist you further, those are my submissions.
There is one further matter. We have to concern ourselves with the cost of the appeal and the costs at first instance.
Yes.
Am I right in thinking that in relation to the costs at first instance, we are not concerned with any application of a Beddoes order because there isn't one?
My Lord, that's right. This question was raised previously, and I think it was raised by my Lord Bell, in fact.
That's correct.
Yes.
That happened, Ms. MacDonald, at the time of the directions hearing, and I specifically asked Mr. Robinson as to the position, and he confirmed that no better application had been made in relation to the first instance privacy order.
Yes.
So there is, on that basis, nothing to preclude us from making an order that the trustee should pay the costs of first instance without an indemnity against the trust estate.
My Lord, yes.
Right. I have no further questions. I don't know whether either of my colleagues have.
Not for my part.
Nor for me, thank you.
Thank you very much. Right.
My Lord, can I roll back a bit further in the timeline than Ms. MacDonald, and in particular take your lordships back to the original Beddoe order, which was made authorizing the executors to defend the application for permission to bring the derivative claim. And your lordships will find that at tab 5 of the record.
Yes.
And it was made on the 8th of January, 2022.
2022, was it? Right. Yes, yes.
2021.
Yeah.
2021, I beg your
Yeah, quite. Yes.
Yes. It's again an order made by the same judge, and your lordships will see the recitals on page 222 that there was a hearing on which counsel for the plaintiffs, that is the executors and the defendants, were heard, and that the counsel for the defense gave his consent to the order that was made. And then if you look forward to the ordering part on the next page, there is an order that the plaintiffs as executors are at liberty to defend the application for permission to commence the action, etc. And there is a corresponding order for the plaintiffs to be indemnified against the costs of the permission application. Now, that is the background to that is that in their evidence and in correspondence, Ms. MacDonald's clients had advanced the proposition that the trustees, the executors, should be neutral. But by the time the matter was dealt with by the judge when making this order, that position had fallen away, and there was no question then of neutrality. The executors were authorized to defend the application. And that's important when we come to the point about MacDonald and that also, like Justice Bell, I keep wanting to call it Alsop Stephen, but it's Alsop Wilkinson.
Yes.
When we come to that, neutrality had ceased to be the standard by consent when this order was made. And the second point I want to make in relation to this order is that by implication it covered not only the ultimate disposition of the permission application, but also interlocutory applications in relation to that application.
So why did you ask for another one?
Mr. Ham, you see that
look,
I'm sorry, I'm not sure who I was interrupting.
I think you're interrupting me. Sorry.
You're both interrupting me.
Yes, well, let me start. I understood you to say that the Beddoes application that we're looking at, the Beddoes order in January 2021, covered everything to do with the permission application, including all interlocutories. Yes. My question was, if it did, why did you apply for another one?
I can only say it was belt and braces. Question whether or not
you can't. That seems to be very difficult. It doesn't seem you can have it both ways. You seek a Beddoes application second time round on the footing that you need one, and then when there's a contest as to whether or not you're rightly given one, you say, "Oh, we didn't need it. We could rely on the January one."
I'm not saying that specifically. I think when one comes to a specific order dealing with the specific matter of an appeal, where one can see that there would be an issue whether this January order extended to it, it was sensible to go back and get that put beyond doubt.
But there isn't any doubt, is there, Mr. Ham, that subsequently the Inghams were taking the position that the executors had a duty to remain neutral, notwithstanding the existence of the Beddoe order in the permission application proceedings.
Well, if they were, that wasn't an appropriate thing. Can I come back to it? The point,
I'm sorry.
which is,
no, just a minute. No, I need to get where we are. You're not saying, are you, that if we were to allow the appeal, or minded, well, no, if we were to allow the appeal in relation to the Beddoes order, in relation to the privacy application, that wouldn't be the end of the matter, because you would still be entitled to rely upon the order made in January 2021.
I'm not saying that.
No.
To the extent that it related to the privacy application, the privacy appeal, being superseded by the subsequent order.
And Mr. Ham, I also bear in mind that in paragraph 17 of the executive's submissions, they seem to suggest that the executors are reconsidering their position in relation to the permission application.
That is what we say, and we say we're intending to go back for further directions. And there are two things. Let me go back. A Beddoe application, there is always implicit, if not expressly, liberty to apply and go back for further directions if circumstances change. That's the point that Sir Robert McGarry was making in Dalloway.
Sorry, the change being the judgment of the Court of Appeal?
Two things: the judgment of the observations made by this court on the privacy appeal, and secondly, the acknowledgement by the Inghams that they would not be seeking to reimburse, they would not be seeking to cast the costs of the derivative action onto the trust estate.
No, but I mean, that, Mr. Ham, seems to me a question which, if the executors had genuinely believed they were at risk in relation to costs, if the Inghams were to be granted their permission application, they could and should have raised and said, let's understand your position. Are you saying that we're at risk in costs, or are you prepared to say that you will?
And that's what ultimately has happened.
Yes, but the key word being ultimately, that's something that I've always had a difficulty understanding the notion that Mr. Kemp put forward, that the estate and the executors were at risk.
Well, all I can say about that is that I have seen derivative actions where that sort of argument has been run. Whether Mr. Kemp knows about that, I don't know.
But very easily been preempted is my point.
I can't quarrel with that. It could have been preempted.
Right.
Be that as it may, the background to the subsequent Beddoe application, which you're now concerned with, was the January order departing from the principle of neutrality.
But I mean, understand what the executive's position is now. Do you say that the executors were not subject to a requirement of neutrality in relation to a beneficiary's dispute?
I do say that. That there is, with great respect to Mr. Justice Lightman, and he and I debated this topic when he was preparing the Isle of Man paper that you've seen, is that there is no absolute principle. Evans, which you've been shown, treats the matter as one of discretion. And
accepting that it's a matter of discretion, the question is how that discretion should be exercised.
Well,
given the facts of the case, and is it not the case here that the discretion should be exercised in favour of neutrality?
Well, not when the in relation to the proceedings generally, the executors have been given liberty to defend, not to be neutral.
Yeah, but why should you not be neutral?
Well, because we are defending the estate. Evans.
What are you defending the estate from?
The claims that are sought to be made in the derivative action.
They're not claims against you, Mr. Ham. They're claims against the Wardman branch of the family, which, if successful, will inure to the benefit of the estate.
They're claims which are brought against the executors, and which they ought to be, arguably, they ought to have been defending.
They're brought against the executors of the Wardman family, not yours.
Not my, and my clients. The evidence is that my executors took advice as to whether they should be pursuing those claims, and concluded that it was not appropriate to do so.
So what?
Well, they have taken that view, and consistently with that, they do not think that it is in the interests of their estate to be.
I'm sorry, I'm obviously being very stupid, but I simply don't follow this. Be it assumed you have taken advice and have been told the claims are not worth pursuing.
Yes.
So you wouldn't pursue them. It's because you've had that advice that it's necessary to have a derivative action for which permission is needed. If permission is granted, it will mean that some judge has been persuaded that there may well be benefit in having the action. If permission is not granted, the matter will go away.
Yeah.
But since what is to happen is either that permission will be refused and everything will come to an end, or alternatively, permission will be granted and the action will proceed at the Ingham's expense, I can't see how the trustees are remotely concerned to participate.
Well, my answer to that, in part, is that they have been given liberty to do so.
I know that they have been given permission. I doubt whether they should have been, but leaving aside, and no doubt the matter will be reconsidered, leaving aside whether they have been commissioned, I require, but being given permission, I'm afraid I still require to understand why on earth the trustees are not simply saying, well, get on with it to the Inghams by yourselves.
At your own expense.
And the answer to that, I think, comes back to the question of whether there could be a claim over against the estate in respect of the costs of the derivative claim.
How could there be?
Well,
and which you've accepted, Mr. Ham, could be preempted by the simple measure of asking the
and the event has been preempted.
Right. So that's the end of that point.
Now,
I think my Lord Justice Smelly is saying something.
I saw a reference to the fact that Mr. Justice Smelling needs to be in another place in 10 minutes.
Yes. I just wanted to alert everyone to that, and the Lord President in particular, that we might have a short break at 10:30, 9:30 Cayman time, which is another 10 minutes or so.
Yes, I'm sure we can do that.
Thank you.
Well, if I can move on to the fundamental point that purpose of a BEDO application is to predetermine whether it's reasonable and proper for trustees, or in this case, executor, to pursue or defend proceedings. And you've seen a passage from Lewin, and you've seen MacDonald and Horn and the three individual trustees case. My Lord, the President referred to a 5-day BEDO application. 3 individual trustees, I think, went over for over 30 days. Of course, a quite extraordinary proposition. But the fact is that my clients have had the benefit of a BEDO order, and our submission is that there is no scope for the middle way, which is put forward by my learned friend, of imposing a restriction on the order. It would completely undermine the whole purpose of a BEDO application. And I adopt what Justice Hellman said about Dalloway and the restriction which Sir Robert McGarry referred to there. That is the implicit, if not express, liberty to go back if a BEDO order has been made and something changes. We're not in that area of country. What is proposed, as I understand it, is that there should be a restriction on the BEDO relief which was granted, which enables a judge or this court to make an order and take it away retrospectively.
Well, that's one thing that's asked for, but another slightly simpler method is we are asked to set aside the order on the grounds it should have been made in the first place.
Well, my Lord, there are a couple of stages. First of all, there are statements in the authorities about full disclosure and so forth. I don't think you've seen the case where it said that it's a situation where the applicants for BEDO relief must put all their cards face up on the table. But in looking at
I understand that. They've got a duty, do they not, to put all relevant matters before the judge?
The judge has to consider if I can go back to real basics, the unreported case of judgment of Mr. Justice Robert Walker, which is referred to in Public Trust 218 Cooper, is the classic explanation of the court's jurisdiction to give directions to trustees or other fiduciaries. And in doing that, the court may either bless a decision which the trustees have made, or it may, in effect, make the decision on behalf of the trustees. And Mr. Justice Robert Walker pointed out that in the context of BEDO applications, which his case involved, the conceptual clarity between the two categories tends to get muddled. And my Lord the President referred to the cosy chat. It frequently is in practice an informal and unstructured conversation between counsel and the judge.
Mr. Ham, I can't get away from the fact that Mr. Robinson, who made the Beddoe application to the judge, is an extremely experienced trust practitioner. And it can't be said that the judge, from her background, wasn't came from the typical Chancery judge background that one sees in Beddoe judges. And does that not make it all the more incumbent upon Mr. Robinson, when he's referred to the Alsop-Wilkinson case in the context of who should be the Beddoe judge, to carry on and point out what that case said in relation to the duty to remain neutral?
Well, can I look at that? That there's a trio of cases: Dalloway, Evans, and Alsop-Wilkinson. And the first two cases, and what Mr. Justice Lightman said in Alsop-Wilkinson was his interpretation of what the Court of Appeal had said in Evans. That was the recent case to which he referred. In my submission, those cases are dealing with a rather different situation to the one we're concerned with here. They are cases where there is an adverse claim against the trust, the effect of which would be to take, if successful, would be to take the whole of the putative trust property and give it to the claimant. So you can't tell, in effect, whether there's a trust for the claimant or a trust for the beneficiaries. And in those circumstances, it makes perfect sense for the trustees to adopt a position of neutrality. But it is not, in my respectful submission, any more than a guideline. And it's a matter of looking at each case in its particular circumstances.
Absolutely. That I think is understood. And when one looks at the facts of the particular case, one can't, as it seems to me, support the statement made by Mr. Kemp that there is no basis upon which the proceedings should benefit the estate. If successful, they clearly will benefit the estate.
Oh, well, I'm focusing at the moment on the privacy application and the appeal. That's a technical matter, and that what the executors did is to go and seek advice from Carey Olsen, which was to the effect that there were no merits in the privacy.
That's not the sole question. Obviously, there is a question as to whether or not the appeal has a prospect of success, the pure merits question. But surely the trustees, in deciding whether to participate in the appeal, need to address their minds to the question as to whether or not, and if so, why, it is for the benefit of the beneficiaries that they should do so.
I entirely accept that. It is an absolutely conventional situation that trustees have to consider what is in the interests of their beneficiaries, what they believe to be in the interests of their beneficiaries, make sure that what they're doing is not for an improper purpose, so far as they can to take into account the right considerations and not to arrive at a totally unreasonable conclusion.
Well, we need a short adjournment now, but I give you notice that I need to understand what conceivable benefit there was for the beneficiaries in the trustees resisting the appeal, because as I presently stand, I have not perceived any. We'll adjourn now, and you can answer my question when we resume.
And-
Maybe go to the breakout room for this purpose.
Yes, yes, please.
Perhaps before we go, we could give council some indication of how long we're likely to be.
Oh,
I did.
10 minutes. No
10
wrong.
minutes, okay. Thank you. We'll go to the breakout room.
Right.
I don't see the breakout room option, which
You have to click the breakout room at the bottom.
yeah, sorry,
But
I have it.
My lords, I was proposing just to switch off my video and mic.
Yeah,
Um,
that's fine. Council to switch off the video and mic, and the judges will go to the breakout room.
well, I think we're all here.
Yes, but we've all moved around, or in my screen, we've all.
Yes. Well, never mind. Just see you differently or in a different place.
Can I start by just picking up something which Justice Bell said about Mr. Robinson, and just to put the record right, Mr. Robinson did not appear as counsel on the Beddoe applications.
Was that Mr. Masters who appeared?
Yes, that's right, my lord.
Right. But Mr. Robinson is the senior practitioner having conduct of the case.
My lord, that is absolutely right, and we're not. Mr. Robinson is not seeking to evade his responsibility or that of as the senior member of the team or of his firm. But I just wanted to put the record right that he wasn't the advocate. Can I come back to, my lord, the president's question, and about the advantage to the estate, and I can, all I can do about that is refer you to a couple of passages in the evidence of Mr. Kemp.
Yeah.
You have tab 4, page 179.
Just a moment.
Yeah. Mr. Kemp deals with the funding of the derivative action.
Hold on a moment.
And he refers to Ingham 2, paragraph 31, and says a close reading of these paragraphs demonstrates that the course of action proposed by the Inghams threatened to visit upon the estate potentially very significant expense in terms of legal costs. And then perhaps you might read to yourselves the next.
Well, can we go back to where it said that is likely?
Well, I think if that's dealt with, I think in paragraph 32.
Sorry, can I just read it? Just leave me some time to read it.
Okay. But this is premised, is it not, Mr. Ham, on the executors failing to follow a neutral position?
As they, and that was the position that they had been directed by the original Beddoe order to adopt.
But if they took a neutral position, which, as it seems to me, that if Mr. Robinson and his team read Alsop Wilkinson, they should have, then, as you acknowledged, it would have been relatively straightforward to preempt the issue of the estate's vulnerability and costs by saying to the Inghams, we propose to take a neutral position. Will you confirm that in those circumstances, no claim for costs will arise as against the estate?
Well, I do come back to what had been said in the Ingham evidence, that they would possibly claim from Mrs. Chappell's estate.
Yeah, but that statement is made in the context of the executors breaching their duty of neutrality and descending into the battlefield and picking sides.
Well, all that was envisaged was that the executors would defend the permission application. And that is what they had been authorized to do with the consent of the Inghams.
No, but sorry, paragraph 32 is in the context of Mr. Ingham stating that, quote, if the derivative action is successful. So he's
Yes.
looking at matters not in relation to the permission application, but at the end of the day, after assuming that the permission application is granted, the derivative action has been pursued to its conclusion.
Well, Mr. Ingham seems, if you look at 33, to be contemplating defending the permission application.
But that's all on the basis that the executors are not taking the neutral position, which as I understand Allsop Wilkinson, that they should have taken.
Well, that was a guideline given, but it's not an absolute rule. And in this case,
and it's dependent upon one looking at the full facts of the case.
Yeah, I think we're at one of that, but in this case, that stage had been dealt with in the original Beddoe application because they'd been given permission to defend the permission application.
But the permission application...
If I might interject here to ask of Mr. Ham, why does it then follow that the executors must have resisted the privacy application, particularly where the beneficiaries had all consented to the Guernsey order?
It doesn't follow.
Well,
No, it doesn't. That's the problem.
It doesn't follow at all, does it?
Yeah. No, it doesn't.
It doesn't follow, but the judge, when she granted the what I'm going to call the specific Beddoe relief in relation to the appeal, thought it did.
But she was wrong.
She was wrong, but she made that order, and the executors in my submission are entitled to act in accordance with an order which is made,
Well,
unless
wait a
until
minute.
it's
No, wait a
gone.
minute. When you say entitled to act in accordance with a law that was made, the executors don't need the consent of to resist the appeal. What they were interested in was getting their costs, if they failed, as they did, out of the estate.
They were concerned to be protected.
They were concerned to be protected. But this is rather important. You say, oh, well, the judge made the order and we went ahead on the basis that she's made it. And effectively, you, the Court of Appeal, can therefore do nothing about it. But that would appear to have the consequence that a Beddoe's order is unappealable.
No, it's unappealable. Trustees seek directions, whether in Beddoe relief relating to litigation or in relation to any other action. They then act on the directions that they're given. It's too late to set aside the original order.
Yes, that's exactly what you say. It is unappealable. You say you can appeal in circumstances where the Court of Appeal is bound not to set aside the order. That looks like
it's a question of timing, and Beddoe relief is all about timing, predetermining.
That goes back to the position that we were talking about at the outset when Miss MacDonald conceded that she could have made application for a stay, and I think my Lord President pointed out that your side, the executors, being on notice of what the Inghams were seeking, could have done the same thing. You could have insisted that the Beddoe appeal be dealt with before the substantive privacy appeal. That didn't happen.
That could have happened, but it didn't either way. The fact is that we did resist the privacy appeal on the footing that we had a Beddoe order.
Yes,
So
but you
I
knew
know
very
that.
well that the Beddoe order was being subject to challenge.
Well, we did, but we were nevertheless, in my submission, entitled to act on that. What did we do? We've been directed to do this.
You hadn't been directed to do anything.
No, sorry. Directed is a word which is used loosely, I think, in these. We were given
wrongly.
liberty to do something on the footing that we would be indemnified.
Indeed, and so isn't it necessarily a prior question why it is that the executors sought to challenge the privacy order in the first place?
Well, that's the question that arose on the Beddoe application and would have arisen on a Timaeus appeal against it.
But what is the answer to a question that I have asked at least once, which Justice Smelly has now asked a second time, and I will now ask a third time? What was the benefit to the beneficiaries in resisting the privacy appeal?
It only relates as a subsidiary to the permission application, and this was part and parcel of the whole process.
That's what I'm afraid the answer I get from that is I cannot identify any benefit to the beneficiaries from resisting the privacy appeal.
Your Lordship has my answer.
Well, your answer is not an answer. I'll do 1/4 time. What is the benefit to the beneficiaries of resisting the privacy appeal?
There's no I cannot and do not point to any specific benefit.
Okay, thank you. Next item on the program. About you understandably say, well, you had the benefit of a Beddoe's order. But if the position is that the judge should never have made it, not least because you had failed to identify any benefit in making it, why can we not set it aside?
Because we have acted on the strength of it.
Well, I know, but of course, whenever there's an appeal, you find that the parties have acted on the strength of the judgment that was made below. The logical consequence of what you're saying is that however unreasonable and irrational the decision of the Beddoes judge is, the Court of Appeal is incapable of setting it aside ab initio. Is that your submission?
Incapable of setting it aside ab initio once it has been acted on.
Even in circumstances where the executors knew perfectly well what the consequences of acting upon it would be if ultimately when the Beddoe order came to be appealed, if they were to lose that issue.
And one might add, and cannot now point to any good reason having sought to get the order in the first place.
Well, I think you've correctly identified the consequences of what I say. There is. Can I just at the risk of showing off, say the only authority that I've been able to deal with the situation of a trustee who's acted under the protection of the court. It's been legislated for in New Zealand, and I'm afraid I haven't, as I only found this authority, I haven't got it for you. Can I give you the reference, which is section 134 of the New Zealand Trusts Act 2019?
No, please send us a copy in due course.
I will send you a copy, and I apologize for not having done so already.
No, don't worry about that. Well, you may find there's a new authority coming into being.
Well, I rather think there may be. but I think particularly in that context, it might be helpful to see how the legislature in New Zealand has dealt with it.
I mean, these are unusual circumstances, and as you know perfectly well, my background is not in the trust field, but it would seem to me profoundly unsatisfactory that the Court of Appeal was unable to set aside an order which the judge shouldn't have made in the first place, and which she made in circumstances where the parties had not drawn to her attention any benefit to the beneficiary for her making it.
Well,
if the Court of Appeal can't set that aside, something has gone wrong with the administration of justice.
I hear what your lordship says. What one also has to think about is that part of the administration of justice is making sure that trustees can resort to the court for guidance and act on it.
Yeah, but the other part is that means that the trustees, who have duties of effectively uberrimar fides, should, before seeking the approval of the court, draw attention to the court, of what they say is the potential benefit to the beneficiaries of the action that they propose to have endorsed, which they never did.
Well, I think we've been
We mean
around
that.
this.
Yeah, we have. I'm sorry. We have. Thank you.
I'll send you the New Zealand authority. Can I come back?
I mean, I don't understand where the New Zealand authority takes us.
It doesn't. It's just to put it in context. New Zealand says where a trustee has acted under the direction of the court, he's protected unless he's guilty of bad faith.
Yeah, but that, if anything, turns out against you because there is no equivalent legislation in Bermuda.
No. I'm not sure that it turns out against me. It doesn't help, except it gives the court some guidance as to what the only legislature, so far as I know, that's actually turned its mind to this has done about it.
Right. Thank you.
So here could the executors be said to have acted in good faith, where they could not discern any good reason of benefit to the beneficiaries for resisting the application?
Well, I say that you wouldn't. They may have been mistaken. The judge may have been mistaken to give the better relief that she did, but that doesn't amount to bad faith on either part.
Right.
Can I circle back to Miss MacDonald's submissions about the grounds on which the better order could be challenged, and I think I think it's common ground that a better order isn't conclusive in all circumstances. I hope it's not seriously in dispute that the Dalloway qualification isn't a authority for what is sought in this case, which is to write into the better order a restriction allowing it to the Supreme Court or the Court of Appeal to override it. What one's concerned to see is whether there has been a sufficient disclosure by the trustees of the circumstances. And that has to be looked at in this case in a context where before the court were not only the trustees, but also the Inghams. And if there were things that they wanted to have thought hadn't been drawn to the attention of the court, they had the opportunity to do that.
And they indeed did so when it came to the issue of what the trustees' duty in relation to neutrality was, because they drew the judge's attention to those parts of Alsop Wilkinson which they say were relevant.
Yes. So the judge's decision may have been mistaken, but it can't be criticised on the basis that there was non-disclosure.
Well, depends what you mean by non-disclosure. There was non-disclosure of any benefit for resisting the appeal to the beneficiaries because there wasn't any benefit to disclose.
But what one's talking about is, I suggest, willful concealment or misrepresentation.
But Mr. Ham, let me go back to, I mean, counsel for the Inghams drew the judge's attention to those parts of Alsop Wilkinson. Counsel for the executors did not. At no point did counsel for the executors say, yes, the Inghams have it right.
He didn't, but the relevant considerations were before the judge, and her decision can't be in that respect, were before the judge. In that respect,
when you say
her
they were
judgment
before
can't
the,
be attacked.
when they were basically unresolved before the judge because you had the Ingham saying one thing and it was not something which was accepted by the executors. And indeed, the executors' case was that it was appropriate for them to weigh in on one side and not to take a position of neutrality.
On the appeal, and I come back to where I started. The original order gave them liberty to defend the permission application, and this is all part and parcel of the permission application.
Well, wait a minute. You now seem to be resiling from what I think you had accepted before. That if we came to the conclusion that the privacy Beddoes order should be set aside, you are not suggesting that you can rely upon the.
I'm not suggesting that I can rely on it as a, so to speak, a freestanding Beddoes order. Right. What I am saying is that the criticism that we didn't adopt a stance of neutrality is a bad one, given that we had already been directed or authorized to defend the permission application.
Mm-hmm. But I have a problem with that, simply because, as we've seen, these certainly the privacy application took, I think Ms. McDonald says 3.5 minutes. There doesn't seem to have been a very thorough investigation as to the basis upon which the executors might oppose the permission application.
Well, wait a minute. The 3.5 minutes was the original Beddoes order by consent, was it not?
Yes.
Yes, that's correct.
Right.
And one does come back to the practical reality that Beddoes applications frequently are. I think the expression the President used was friendly chats. They are informal.
Well, the executors don't seem to have been particularly friendly in relation to the privacy appeal.
And
not
in
least by
this context, Mr. Ham, I think it may be important to get your clear views on the distinction between being directed and being authorized, because
yes,
them interchangeably. Is it not accepted that, particularly because of the informal nature of these Beddoes applications, the trustee must continue to assess for itself whether or not it should take a particular action?
I accept that. It was at liberty to do so. It's at liberty to oppose, but it has to keep that.
Yes, but it has an
consider from time to time whether to review that.
It has an ongoing obligation to decide whether it
I accept that.
Yes.
Right.
I think we've covered a lot of the ground.
I think we have, thank you. Yeah.
One thing I think I haven't dealt with is the objection that Justice Sir Williams was the wrong judge. And I respectfully agree that it was most unsatisfactory that you should have the same judge hearing the substantive proceedings and the Beddoe proceedings. That was actually what Mr. Justice Lightman decided in Alsop Wilkinson. Everything else he said is, I think, over to dictum. He said the procedure was completely wrong. Here, I understand, and I'm afraid I don't have it in front of me at the moment, that the executors took the point that it was inappropriate that the judge should be hearing the privacy application, given that she was the Beddoe judge. I'm looking at Mr. Robinson to make sure that I've got this right.
I didn't understand that to be the case.
I think that
as I say, I'm afraid I don't have readily to hand. I have it electronically, but not on the screen, the privacy record. But I'm told that if you look at tab 17, page 163 of the record, you'll find that that's dealt with.
I don't have a tab 17, so of the record.
Well, I've got it. I've got separately in her decision of the 16th September, at paragraphs 24 and following, she dealt with the complaint that the Beddoes judge ought not to have. With the complaint the Beddoes judge ought not to have made the privacy orders.
So we're looking there at
the other record, maybe the confusion.
Yes,
that's from the judge's inter partes judgment on privacy appeal.
Yes.
Privacy order.
On the privacy application.
Yes. And does she say that the executors thought that she should not hear that? I didn't understand that to have been the case.
Well, perhaps Mr. Robinson could deal
Yes,
with this.
I'm happy to jump in there. In paragraph 24 of the judgment below in the privacy order matter, she records at paragraph 24.
Before you go on, Mr. Robinson, can you tell me where I find that?
Well, it's tab 17 of the privacy bundle.
Which I don't have, so that.
Sorry, my lord, about that. I can't.
Let me just see if I've got it in other papers, can I?
Robinson, is this something that you can email the court so that it can be passed on to the judges?
I will do my best.
Yes, please. I do not have it either. All I have is the Beddoe bundle, record of appeal.
Right. So, Mr. Robinson, if you could give me again the actual date. We're talking about Justice Sir Williams' ruling.
Ruling of the 16th of September 2021. The ruling which was under appeal in the privacy appeal.
Yes. Obviously, I've seen it numerous times, but
it'll take me a few moments to find it and send it, I'm afraid.
I'll just go to my desk and I can send it on.
I mean, we'll be able to find it in the considered judgments on the website, will we not?
Yes, my lord. The only point which Mr. Ham was making is that at first instance on the privacy issue, we submitted that the judge was, as the Beddoe judge in the permission application, shouldn't hear the privacy application.
Right, and that appears from the ruling.
Yes.
Could you give me paragraph number?
She deals with that at paragraphs 24 to 31, and she starts paragraph 24 by saying that my submission was that the Beddoe judge ought not to be the judge who deals with the main action, and then she analyzes that, she rejects that, but that was not appealed.
Right. So
wait a minute, but that's a contention. the judge who made the original Beddoes action, that's to say the one it made in 2020, should not have dealt with the privacy application. Is that right?
That she ought not to have dealt with the
Yes.
privacy application, because the privacy application.
She ought not to have dealt with the privacy application because she had made the original order in 2020.
Yes, that's right, my lord.
And what we're now concerned with is whether, having made the privacy order, she should also have been the Beddoes judge deciding whether the trustees should be authorized to defend the appeal, which is a different question.
Yes, my lord, but she was the better judge in the permission application. She'd granted the privacy appeal was in the permission application, so she's sitting in the same capacity.
Well, yes, but yes, he is sitting in the same. Well, yes, but the difference is that she makes the original Beddoes order, which nobody seeks to appeal. She then makes the privacy order, which people do seek to appeal, and she then makes the Beddoes order in relation to the privacy order. In other words, she gives leave to the trustees to resist the appeal against her own decision.
That's correct, Lord.
That's what shouldn't have happened.
What, I didn't hear you, Mr. Robinson. Did you agree with that?
Yes, I agree with that.
I did agree.
But the objection that you made was not that she was going to be the judge in the main action, but that she had been the Beddoes judge in relation to the permission application.
Yes, that's right.
Right.
If I can pick it up, really the point we make in relation to this is that the executors, having raised the difficulty of the dual capacity of the judge, it would be inappropriate that they should lose their protection at the later stage on the same basis.
Yeah.
Now, my lord, I understand that in jurisdictions with a relatively small judiciary, there are practical difficulties about having separate Beddoes judges, of course, but it really is unsatisfactory. But it would be wrong in my submission that we should lose our protection on that ground. That's the submission.
Can you just remind me where the opinion is? I've lost the reference, which the judge saw from Kerry Olson.
Yes, I can do that. It is tab 9.
Yes.
And the opinion begins, the opinion itself begins at page 231 and runs to page 243.
Well, that's not tab 9 for me, but
No, it's not. But 231 is indeed the opinion, which is Exhibit SWK5.
Yes.
So it's an exhibit.
Yes, tab 6.
Kemp's affidavit.
It's Exhibit SWK5, so exhibit to Mr. Kemp's affidavit of 28 January 2022.
Yeah, Kemp 5.
That's tab 4, I believe.
yes, I mean, if you go to 235, it records at paragraph 16 that the executors apply to set aside the privacy order on the basis that the judge who sanctioned the defendant's decision to defend and oppose the permission application ought not to have heard the privacy order in respect of the permission application. That's the same point. Yeah, I follow.
Same point.
Yes, I see. Thank you. Right, Mr. Ham, are we done?
I think we're pretty near done, except I was going to pose the following question. If if you were minded to set aside the privacy better order, in considering the question of costs, I would invite you to consider what the position would have been had there been no better order.
That is to say, the position in respect of the first instance application.
Yes. Well, I'm not sure that I've correctly understood the question. Could I ask you to?
You said that if we're minded to set aside the privacy order on the basis that there was no BEDO application relating.
If you were minded to set aside the BEDO order relating to the privacy
yes.
appeal.
And my comment was that that would put us in the same position as the first instance ruling on privacy, where there was no BEDO order.
Well, I've made my submission to you on that, namely that the original BEDO order is wide enough to cover that.
Right, but
you accept it or not, as you will.
So if we're minded to set aside the BEDO privacy order,
then what would the position have been?
And what do you say it would have been?
It would have been that the appeal would have had to go ahead to get to challenge the existing order, the existing privacy order.
So the appeal would have gone ahead before the hearing of the privacy appeal.
No, the privacy appeal would have had to go ahead in any event, is the point I'm trying to make.
But before. So, I'm sorry. I think I understand what you're saying. If the BEDO order had been argued and had been set aside, the privacy appeal would then have to be heard on that basis.
Yes, that's right.
Is the point, Mr. Ham, that the costs of the appellants would have been incurred anyway? Is that the point?
Exactly. Exactly.
Well, would we not have made an order for costs against the second and third respondents? The Wardman executors.
Well,
Yeah, I mean, the second and third executors are surely the capital.
Oh, sorry,
capital executors.
I mean the first and second executors.
Right.
Well, you might have, but at that stage, they are standing neutral, and it's is it appropriate, I asked, that they should have an order for costs made against them then?
Yeah, but we're talking about a hypothetical which is not this case.
Well,
The fact is that the executive did contest the appeal unsuccessfully and incurred costs. And the question is whether they should be entitled to recover those costs from the estate.
yes.
Yeah.
Which would effectively give the Inghams a Pyrrhic victory.
Well, the Inghams would have suffered part of that, but burden of cost, yes.
Yeah. Which would you say would be just?
Well, if we've got to the position, as I analyse it, that the executors have properly, on the basis of their original Beddoe order, resisted the privacy application, and then they stand neutral. Is it?
I don't.
I mean, I'm sorry. I've made the point.
Yes.
I'm sorry, I'm going to return to something for about the fourth time, but I thought you to say at one stage that the original Beddoes order was part of the history, but that if you failed on the appeal, you were not entitled to say, oh, well, there's the original Beddoes order.
No,
let me finish the question first. That covers the cost of the appeal, which you appeared to say a moment ago. Let me finish the question and then answer it. You appeared to me to say a moment ago that in relation to the first instance, where there was no Beddoes privacy order, you were entitled to rely upon the original Beddoes order.
Yes.
Is that what you're saying?
I'm saying that it's wide enough to cover interlocutories in the permission application, which the privacy application was.
So we get the extraordinary arrangement that in order to deal with the costs at first instance, it would be necessary to set aside the original Beddoes order. But because you made an application for a privacy order in relation to the appeal, if we set aside the privacy order, the original Beddoes order is inapplicable.
I say that the original Beddoes order, made with consent, has been superseded in relation to the privacy appeal.
Oh, it has been superseded by what?
By the specific application, Beddoe application, focused exclusively on the privacy appeal.
So on that basis, you made an order that you didn't need. You got an order that you didn't need, namely a Beddoes order for the privacy appeal, upon which you may fail. And if only you hadn't applied for the privacy order, you would have been entitled to rely upon the original Beddoes order.
Yep.
Good
Lord.
That's what you're saying, isn't it, Mr. Ham?
Yeah, it is.
That is what I think that follows. Save for this, that I'm not sure. I'm not sure that I would have regarded the original Beddoe order as extending to appeals, but that's a point of construction.
Right. Okay.
Unless you've any further questions for me on the Beddoe aspect, I think I've covered the ground that I wanted to cover.
Right.
What I haven't said anything about, and we didn't say very much in our skeleton about, is the basis of taxation.
Right.
And standard versus indemnity.
Which always seems to me, Mr. Ham, to be rather overstated, because the actual amount that you get on taxation doesn't change. It's simply the side which has the burden of proof in relation to reasonableness.
Well, that is perfectly true. How it works out in practice, what one is told different things in different cases.
Well, I mean, I think that the problem comes from a bygone time when there were actually different amounts awarded in costs. I mean, typically the way that it used to be was that if you got standard party and party costs, you had fixed amount that were payable. If you got indemnity costs, the solicitor's / attorney's bill was the subject of the indemnity cost order. So you were dealing with different amounts. That is no longer the case. It's simply a question of the party on whom the burden to establish the reasonableness of the amount in question.
Well, that sounds right, if I may respectfully say so. And the question which it is framed as has there been some departure from the norm? And I'm not sure what the norm is for the issues that arose in this litigation, which are highly unusual. But I don't propose, unless you want me to make any particular submissions about that.
Could you just help me on one last thing? I may not have made an accurate note of it. You said there was a time when the Inghams confirmed that they wouldn't be seeking, if the derivative action went ahead, any costs
Yes.
against the estate. When did that happen?
I think
Could I just ask that you repeat that? My screen froze for a moment there.
I was saying that Mr. Hammond said that at some stage the Inghams had confirmed that if the derivative action went ahead, they would not be seeking any costs against the trust.
Yes, I
and
understood.
my question was, when was that?
I think the answer to that is the 21st of March.
Of which year?
Of
this year.
This year.
2022.
Okay, thank you very much. Well, I have no further questions. I don't know whether either of my colleagues has.
Not for my part.
I'm wondering what it is that Mr. Ham is saying in response to the argument on indemnity. I've heard what my Lord Bella has said about the basis for taxation, but what the other side seems to be saying is that you have acted unreasonably, such that an order to indemnity cost should be granted.
They say we've acted the conduct of the litigation has gone outside the norm because we have acted aggressively and unreasonably. And I think that probably leads us back into the same arguments, or very much the same arguments, which we've been having in relation to the Beddoe aspect.
Yeah, thank you.
In the judgment, that would seem to me to lead to an order for indemnity costs.
I mean, you have a finding against you that your conduct has been improper and unjustifiable, as well as hostile and potentially governed by self-interest. That might seem to creep into indemnity costs territory.
Well, I haven't made much of this, and I don't have much to add.
Right, thank you. Thank you very much. Ms. MacDonald, have you any matters you want to say in reply?
My lords, extremely briefly, I'll be no more than a couple of minutes. Your lordships may recall that at the hearing on the 14th of March, there was a discussion about what evidence there was about any liability that might be imposed upon the estate for costs. And I showed your lordships a page in my client Jonathan Ingham's affidavit, which appears, appreciate you don't have this to hand, but can I simply give you a page reference?
Yes.
It's in the privacy bundle at tab 3, page 99. And he says there that there's no reason for the executors to incur costs.
Are you looking at paragraph 53?
But yes, paragraph 53 to 54. He says at 54, there will be no need for the executors to incur any further significant legal expenses in relation to the derivative claim. I submitted on the 14th of March that covered the question of adverse costs. And 53 covers the question of costs to be incurred in pursuing the claim. So I don't accept Malone and Friends' submission that it wasn't until more recently that that point was covered by my clients.
Right, but Mr. Ham said it was covered on the 21st of March.
Well, I think it was covered again.
Yes, well, the week, but the 7 days between you, I'm not sure that anything's going to turn on that.
Well, my lord, simply that as far as the executors are concerned, they knew upon receipt of the affidavit I've just referred to, February 2020, that there was no risk to the estate.
Oh, that's the affidavit. You didn't tell me the date of the affidavit.
I'm so sorry, my fault entirely.
Yes.
It's 26th of February 2020. It's the second affidavit of Jonathan Ingham at paragraphs 53 to 54, yes. And the page reference is in the privacy bundle at page 99.
Yes.
Right. My learned friend has described the privacy set aside. I'm so sorry.
McDonald, I do apologise. I appear to have an unstable internet connection and I lost you for about half a minute. The last thing I got was just a confirmation of the date of the Ingham affidavit, which is 26 February 2020.
My lord, yes. My follow-on submission was simply that the executors have known since then that there was no risk of adverse costs against the estate.
Right.
On a separate point and a very short point, my lords, I don't accept, my learned friend said that the privacy application, in other words, the executor's application to set aside a privacy order which had already been made, was a technical matter. And just a moment ago, he described it as being highly unusual. Those descriptions, my lords, in my submission do not sit with the January 2021 original Beddoe order in relation to the permission application. There was no concept at that time of any application for a privacy order, let alone an application by the executors to set aside such an order. Nobody was contemplating any such highly unusual or technical application. And the logical conclusion of any suggestion that the privacy application was covered by it seems to lend any Beddoe order with a sort of carte blanche status, which it simply shouldn't have.
I'm sure I can find it from Mr. Hanlon's affidavit, but the date when the documents were disclosed to your client in Guernsey.
I'm not sure that he did put a date in it, probably because he couldn't.
Because he regarded himself as constrained by the Guernsey court in that regard.
As am I, yes.
Yes, I understand.
The order in Guernsey was made on the 24th of May, 2021.
Right.
Yes, I don't think it records in the order when the documents were disclosed within the Guernsey.
But we know that by 24th May 2021, they had been.
Yes.
So you say, as I understand it, that when the order was made in January 2021, that the plaintiffs were at liberty, to defend the application for permission to commence a derivative action. That should not be treated as extending to an application to set aside a privacy order made some considerable time later.
My lords, yes, it did not. Precisely, it did not give them authority to defend the permission application on a no holds barred approach, come what may. It
Yes,
gave
yes.
them authority to defend the permission application on the basis of what was then known to the parties,
Oh, I see.
and indeed to the court, but particularly to the parties, because it was made by consent. And the reason for that was also discussed on the 14th of March. And I submitted at the time, and continue to submit, that it was made by consent for purely commercial reasons, because at that time it was contemplated that we would be getting straight on with the permission application to be heard in July, and that somebody would need to oppose it.
But your important point there is that the privacy order was not in the contemplation of the parties or indeed the Beddoe judge.
No, it absolutely wasn't.
I'm not sure for the point about somebody needing to oppose the permission application.
My lord, let me slightly qualify what I've said. It's, I think, generally recognised in the authorities about Beddoe relief that where a trustee or fiduciary is authorised to oppose or to take a substantive position in litigation, it's possible that it can be to assist the court. And that one of the reasons why the court considers at the Beddoe stage who else might be involved substantively is that, for example, it might encourage the fiduciary to themselves encourage a beneficiary to take a substantive role. And that if they can't or won't, then it can be appropriate to authorise a trustee to argue a substantive point, even if it isn't particularly meritorious, to entirely to assist the court at the hearing.
And is your understanding of the basis on which your clients consented to the original Beddoe order, is it?
Well, that's one of them, my lord. I mean, as I said earlier, for commercial reasons, it was thought not a fight worth having. We just wanted to get on with the permission application and have it heard in July.
Of last year.
Yes,
Yes.
1 year ago.
But I think your lordships already have the point that we made in our written submissions, that the hearing really was incredibly brief and did not involve any consideration of the factors that should have been considered had it been adversarial. And my lords, my absolutely final point is that about the dual capacity of the judge, being the Beddoe judge and the judge who've just given judgment that was sought to be appealed. I do take Mr. Ham's point about jurisdictions where there are not very many judges, but I don't accept that that point is really applicable in these circumstances, where it's not a question of the sort of interlocutory matter being dealt with by a Beddoe judge, which is what the judge was considering when she gave her September 21 judgment. Here, you've got a judge being asked to grant Beddoe relief for an appeal from her own judgment. It's very different, and therefore the point isn't applicable.
The incentive to invite somebody to support your judgment in front of the Court of Appeal when it's said to be wrong might be thought to be strong.
Right. My lords, unless I can assist you further, those are my submissions.
No, we are most grateful to counsel for their concise and helpful submissions and for participating in this remote hearing. I regret that it's not in person. We will obviously take time to consider our judgment and we'll deliver it as soon as is reasonably possible. Thank you very much.
Thank you.
We'll retire to our room if we may.
Actually, I would ask that the court remain and the parties could leave.
Okay.
Right.
Thank you.